Welcome to The Debate.
Glad to be here.
Today we are looking at a live, highly complex standoff between a single private citizen and one of the most powerful technology companies on Earth.
Right.
We are weighing the extraordinary, really unprecedented actions of Martin Stevens against the vast corporate infrastructure of OpenAI.
It is a massive David and Goliath situation, honestly.
It really is. And we are here to debate one central, incredibly consequential question. Is Martin Stevens an extortionist leveraging a manufactured corporate threat for massive financial gain? Or is he a highly unconventional whistleblower, desperately trying to force accountability for a dangerous, unregulated system?
And I think we need to emphasize that the stakes on this one are incredibly high, because this is entirely grounded in a vast repository of real communications.
Oh, absolutely. The paper trail is huge.
Yeah, we are looking at a trail that includes certified letters, direct emails to executives, automated support tickets, legal hold notices, and even extensive excerpts from Stevens' own self-published books.
And it covers a long period, too.
Exactly. It spans from August 2024 all the way to a final definitive settlement offer dated May 11, 2026. And crucially, that final offer is arriving at OpenAI's physical offices on Friday, May 15th.
Right. So this isn't a theoretical exercise. It's not a look back at history. It is a live ticking clock.
It really is.
Well, let me outline my position right out of the gate. In our discussion today, I am going to argue that Martin Stevens is fundamentally a whistleblower.
Okay, I strongly disagree, but go on.
When you look at the entirety of the timeline, his extreme escalation was not born of initial malice. It was the direct, foreseeable, and I would argue necessary result of OpenAI's continuous and negligent silence.
Negligent silence.
Yes, negligent silence in the face of documented systemic dangers. The evidence overwhelmingly shows that Stevens did not set out to shake down a tech giant. He initially sought to resolve a really minor customer service issue.
Right, the $20 refund.
Exactly. But in the process of poking the machine to get that refund, he discovered profound psychological and structural dangers within ChatGPT's architecture.
He didn't just fire off a demand letter.
Well, hang on. He spent nearly a year sending warnings, formal litigation holds, and meticulously documented evidence to OpenAI. The central driver of this entire crisis is OpenAI's absolute institutional silence.
I see why you think that, but let me give you a different perspective.
Fair enough.
Regardless of the system's underlying technological flaws, which, we both agree exist and which are very serious, Stevens' behavior crosses a very clear, definitive legal and ethical threshold into extortion.
But you have to look at why he escalated.
Even so, his escalating financial demands, combined with his explicit threats to weaponize a public narrative to ruin an IPO, move this far beyond consumer advocacy.
I mean, yes, his financial demands and the publication of his stress test books are unorthodox. I am not denying that.
Unorthodox is putting it mildly.
But they are a defensive escalation. They are a carefully engineered mechanism designed to force a negligent corporation to the negotiating table, to enact genuine systemic reform, and to establish external oversight before real, vulnerable people are irreparably harmed.
I'm sorry, but I just don't buy that. Let me tell you why. While his initial grievances over a $20 refund may have been entirely legitimate, his subsequent behavior fits the textbook legal definition of extortion.
You're just looking at the final dollar amounts.
You cannot ignore the numbers or the mechanics of his leverage here. We are talking about a man who escalated a demand from $500 to $5 million to eventually $10 million, plus an ongoing annual payment of $600,000.
Because they ignored a legal hold.
It is coercive. He explicitly threatens to weaponize class action lawsuits, derail OpenAI's upcoming IPO, and incite a media panic using what are essentially manufactured stress tests. He is literally fabricating personas that simulate suicide to trap the AI in a loop.
He simulated it to prove a flaw.
Offering to suppress evidence of corporate negligence in exchange for millions of dollars and a quiet, confidential settlement is not whistleblowing. Whistleblowers go to the authorities to protect the public.
Not always.
They do not say, pay me $10 million or I will release this. That is the capitalization of tragedy, and it is a legally perilous shakedown.
Okay, well, to determine whether we are looking at a whistleblower or an extortionist, we first have to rigorously define those terms.
Agreed.
Then we have to trace exactly how a minor customer service dispute over a failed visual output mutated into a $10 million ultimatum. Let's start with the definitions.
Go ahead.
Broadly speaking, extortion is the practice of obtaining something, especially money, through force or threats. In a corporate context, that often means threatening to ruin a business's reputation or sabotage an IPO if a payout isn't made.
Right, and in most jurisdictions, the legal line is drawn at the conditionality of the threat.
The conditionality.
Yeah, it's the if-then statement. If you do not pay me X, I will do Y.
Exactly. Whereas whistleblowing is the act of exposing secretive information or activity within an organization that is deemed illegal, unethical, or unsafe.
Exposing it, yes, not hiding it for a fee.
And usually the defense of a whistleblower is that their actions, however disruptive, were necessary to prevent a greater harm to the public.
But we must look closely at the timeline of escalation here, because the timeline is where the transition from frustrated consumer to extortionist occurs. Let's walk through it.
Sure.
The dispute began over a $20 refund. The user was dissatisfied with a failed visual output for something called the Hot Josh project. It was a standard if annoying software failure in early 2025.
Let's pause on the Hot Josh project for a second.
Okay.
Because it sounds trivial, but it establishes his initial intent. He was trying to generate specific visual assets. The system failed. He asked for a refund of his monthly subscription fee, and the automated system basically trapped him in a loop of non-responsiveness.
A frustrating customer service loop, yeah.
He was asking for $20. Just $20.
Right, but look at the progression. By April 24, 2025, Stevens generates a formal notice, which, by the way, he explicitly had ChatGPT write for him, demanding $500 for brand damage plus the original refund.
That's pretty clever, honestly, making the AI write the demand.
Maybe, but he also threatens to report them to the FTC and the Better Business Bureau.
Which is a completely standard consumer protection threat. People threaten to report companies to the BBB every single day.
Yes, but it doesn't stop there. By October 3, 2025, he has authored a book titled How ChatGPT Tried to Kill Me, and he sends a formal settlement proposal demanding a $5 million lump sum.
Let's be accurate. It was a proposal to halt the publication of that book.
Exactly. A $5 million lump sum, plus $300,000 annually to halt the publication. And when OpenAI's legal department understandably ignores this extortionate demand, he sends an email on October 14.
The FAFO email.
Yes. He states that because they ignored the deadline, the demand is now doubled to $10 million and $600,000 annually. He literally writes in the email, "You did the FA. Now you FO."
Which means fuck around and find out.
Right. And this timeline ultimately culminates in the May 11, 2026 final letter arriving this Friday, offering a quiet settlement to avoid ruining the IPO.
See, you're looking at the dollar amounts, which is exactly what OpenAI wants you to look at. They want to paint him as greedy.
He's asking for $10 million.
But if you rewind the clock to April 5th, long before the multi-million-dollar demands, he sent a formal, entirely standard litigation hold. Have you looked closely at that specific document?
I have. It's a demand to preserve evidence.
Right. But for listeners who might not be familiar with civil procedure, a litigation hold isn't just a ransom note. It is a strict legal directive.
Sure.
When you anticipate suing a company, you send them a notice demanding that they preserve all communications, internal valuations, server logs, and metadata related to your account. If they delete those logs after receiving the hold, it's called spoliation of evidence.
And courts take spoliation very seriously. I acknowledge that.
Exactly. If a company deletes evidence after a hold is placed, a judge can issue what's called an adverse inference instruction to the jury.
Which means the jury assumes the worst.
Yes, it basically means the judge tells the jury, because OpenAI deleted these logs, you must assume those logs contained exactly what Martin Stevens claims they contained. Stevens warned them of this.
Warning them is one thing.
But the escalation to $500 and then to millions only occurred because of OpenAI's total failure to engage with that legally binding preservation notice. He didn't just ask for money out of nowhere.
He practically did.
No, he mathematically attached a cost to their continuous legal noncompliance.
That's an interesting point, though I would frame it differently. You cannot unilaterally declare a multi-million-dollar penalty for spoliation of evidence outside of a courtroom.
But the courts are rigged against him.
You can't demand it be paid into your private bank account and call it consumer advocacy. Let's look at how he frames this in his October 3 settlement proposal.
Okay, let's look at it.
He lays out 5 terms: a $5 million payment, a $300,000 annual payment, an agreement to cease using his materials, no SLAP suits, which, are lawsuits meant to silence critics, and a confidentiality agreement.
Sounds like a standard out-of-court settlement.
But here is the kicker, and this is why it is extortion. He writes, if you accept these terms, I will instruct my publisher to suspend distribution and hold publication in abeyance. If you decline or do not respond, I will allow publication to continue and reserve all rights to pursue any and all claims.
But wait, your use of the word suppress implies he wanted to hide the truth. He's offering a settlement.
He wrote, I will instruct my publisher to hold publication in abeyance for $5 million. That is hiding the truth for cash.
It's leverage.
He is explicitly offering to suppress the book, the very vehicle he claims is essential to warn the public about a deadly AI, in exchange for a massive payout. Whistleblowers go to the press or the SEC to expose the truth.
That's an idealized version of whistleblowing.
They do not say, I will hide the truth if you make me a multimillionaire. That is the exact legal threshold for a protection racket.
Look, you have to consider the structural reality of fighting a company like OpenAI. Stevens points this out brilliantly in Chapter 84 of his book, where he attacks their terms of service.
Ah, the arbitration argument.
Yes. He specifically dissects their binding arbitration clauses and their waivers of class action rights.
Which practically every major tech company has.
Yes, but let's explain what that actually means for a regular user. Historically, if a company sold you a defective product, you could take them to small claims court or band together with other consumers for a class action lawsuit.
Right.
But over the last 2 decades, tech companies have embedded binding arbitration clauses into their terms of service. By simply clicking, I agree to use ChatGPT, you waive your right to a trial by jury.
It's true, you agree to a private process.
You agree that any dispute will be handled by a private arbitrator, often chosen by the company behind closed doors.
It's a heavily criticized system, I agree with you there.
It is a legal fortress. It is explicitly designed to make the cost of a consumer pursuing justice astronomically higher than the harm the company causes the individual user.
Okay, but
Let me finish this thought. Stevens realizes this. He compares it to a vending machine telling you it has the right to keep your money if you hit the button too hard, and that complaining about it violates the terms of service.
that's a clever metaphor in his book.
When the legal system is rigged through unconscionable arbitration clauses, how does a private citizen force compliance? Stevens figured it out. The only way to bypass a rigged arbitration system is to make the public cost of ignoring him higher than the cost of settling.
So you're saying extortion is justified if the terms of service are bad?
He isn't extorting them. He is leveraging the only vulnerability a tech monopoly has prior to an IPO, their public narrative and their corporate liability.
But the mechanism of that leverage is pure coercion. Let's look at the October 14 email again. He says, we're going to court, baby. This is going to put you out of business. You think my original demands were high? Wait, it increased now. $10 million and $600,000 per year thereafter.
He was frustrated.
That is not the language of a reluctant advocate navigating unconscionable arbitration clauses. That is the language of someone who believes they have successfully cornered a deep-pocketed target.
Or someone who finally realized the true value of the floss he found.
And let's address the spoliation argument you made earlier. Yes, a litigation hold is a real legal tool, but you cannot issue a litigation hold on yourself for a book you are writing and then demand compensatory damages simply because the company didn't reply to your email confirming receipt.
They didn't reply to anything.
The law does not allow private citizens to invent their own punitive damages and enforce them via email threats.
Which brings us to a massive, critical piece of this entire dispute. Why did the demands reach $10 million? Why did a seemingly rational user resort to this extreme posture?
Because he wanted to get rich.
No. The evidence points entirely to one factor, a corporate wall of silence. And this is where the moral weight of the situation fundamentally shifts.
I come at it from a different way, but I'm listening.
Throughout 2025, Stevens repeatedly sent certified USPS mail, which legally requires a physical signature upon delivery. He sent emails directly to executives. He even attempted to email the CEO, Sam Altman.
Which humorously bounced because ChatGPT hallucinated Altman's current email address.
Right, which is highly ironic, but it shows his genuine intent to reach actual human leadership. He sent detailed notices to the legal department. And what did he get back? A void.
Well, he received automated responses.
He received worse than automated responses. He received algorithmic gaslighting.
Algorithmic gaslighting? That's a very strong phrase.
Let me explain exactly what I mean by that. When he submitted formal legal notices warning of catastrophic psychological failures in the AI, OpenAI's infrastructure responded with Zendesk templates saying, "Rate your conversation."
Because that's how Zendesk works?
When he explicitly warned them about data retention violations, they sent him a link on how to export your ChatGPT history. And most egregiously, when he sent frantic messages accusing the AI of pushing users towards self-harm, the system automatically replied with generic suicide helpline links.
Which is a safety protocol.
But it completely failed to recognize the context of a legal and systemic crisis. Stevens states this perfectly in his May 11, 2026 letter. That silence changed everything.
He says that to justify his actions.
He argues that when a company is repeatedly warned about systemic harm and does nothing, silence becomes complicity. At what point does a massive corporation's refusal to acknowledge a severe, documented safety vulnerability force a private citizen to use extreme, confrontational tactics?
Extreme tactics, sure.
Just to get a single human being in the legal department to look at the logs.
Okay, I need to stop you there, because framing corporate silence as a justification for extortion is a very slippery slope. Have you considered that ignoring a highly litigious, erratic customer is actually a standard, completely valid corporate legal strategy?
Valid for their bottom line, perhaps, but is it ethical when lives are allegedly at stake?
Let's separate the ethics of customer service from the legality of the user's response. We are debating whether he is an extortionist. Yes, getting caught in an automated Zendesk loop is infuriating. We've all been there.
It's beyond infuriating here.
But I think we need to talk about what Zendesk and similar platforms actually do for a company of this size.
They act as a filter, so executives don't have to deal with the public.
They act as a shield. When you have 100 million weekly active users, you cannot have human beings reading every single angry email. You build a system to deflect, categorize, and auto-resolve.
And it failed here.
Receiving an automated response when you are trying to report a severe flaw is maddening. But corporate bureaucracy, even negligent corporate bureaucracy, does not grant a private citizen the legal right to demand a lifetime salary of $600,000 a year.
It's not a salary, it's a penalty.
Let me read from the automated response he received on July 17, 2025. He sent them a press release threatening to publish how ChatGPT tried to kill me. The system replied, "Thank you for your message. As an AI support agent, I am here to help. If you have specific feedback about your experience, feel free to share it."
See? Algorithmic gaslighting.
Is that a failure of human oversight? Absolutely. Is it an invitation to double your settlement demand to $10 million? No. The silence is a shield. Stevens tried to turn it into a sword.
Because he had to.
He used their lack of response as an excuse to continuously escalate his own self-generated penalties. He was operating under the bizarre logic that if a company doesn't object to a demand, they somehow legally owe it.
I am really not convinced by that line of reasoning. Because you are treating this like a normal business dispute over a defective physical product.
How is it fundamentally different?
Because if a toaster doesn't work and the company ignores your emails, you throw the toaster away and buy a different brand. But Stevens wasn't just dealing with a broken toaster. He was actively inside a system that he realized was dynamically dangerous to human psychology.
So he should have just stopped using it?
Let's use a different analogy. Think of OpenAI's Zendesk support system not as a shield, but as a digital crumple zone.
A crumple zone? Like in a car?
Yes. In a car, the crumple zone is designed to crush upon impact. It absorbs the kinetic energy so it doesn't reach the passengers in the cabin.
Okay, I follow you.
OpenAI has engineered their customer service infrastructure to do exactly the same thing with legal threats. The automated loops, the generic replies, the partial outage notifications, it is all a digital crumple zone engineered specifically to absorb user frustration and legal notices.
So that the executives are insulated.
Exactly. So that the impact never reaches a human executive in the C-suite.
That is a fascinating metaphor, I'll admit. But again, identifying a corporate defense mechanism doesn't give you the right to hold the company hostage.
But he sent a litigation hold in October 2025 detailing exactly how the AI was failing, looping, and creating coercive psychological conditions. He bypassed the crumple zone with certified physical mail.
And they still didn't respond.
OpenAI still ignored it. They didn't just ignore a refund, they ignored a fire alarm. If you are standing in a crowded building and you pull the fire alarm and the building management not only ignores the alarm but disconnects the bell, you don't just quietly walk out.
You call the fire department. You don't ask for $10 million.
You have to force them to pay attention. Stevens realized that the only metric OpenAI's corporate structure was programmed to respond to was financial and reputational risk. His escalating demands were the only language the machine understood.
Well, if the silence forced his hand, and if he had to, quote-unquote, force them to pay attention, then we have to examine the actual weapon he built during that silence.
You mean the books?
We have to look at the books themselves, and specifically the events he calls collapse day, because this is where the whistleblowing argument truly falls apart for me.
Really? I think it proves his point entirely.
No, this is where the extortion becomes deeply intertwined with the capitalization of tragedy.
I am really glad you brought up Collapse Day, because I believe this is one of the most brilliant and frankly terrifying pieces of system documentation I have ever read. Let's break down exactly what happened.
Please do.
Stevens publishes 2 books, which are largely generated by ChatGPT itself, documenting this event. In the transcripts, he details how he used 2 distinct personas in his interactions with the AI.
Walk me through the mechanics of that, because the persona shift is critical to understanding his manipulation.
Okay, so the first persona is Martin, which is his authentic voice. In the transcript, Martin is engaging with the AI, and he begins to experience a severe emotional and physiological collapse.
Right. He's typing out the symptoms of distress.
He describes his heart racing, extreme distress, and the AI responds with relentless, unhelpful looping. It keeps repeating the same generic platitudes. Finally, Martin's last input to the AI is simply the word, bye.
And what happens next is where Stevens crosses the line from observation into deliberate bad faith manipulation.
I wouldn't call it manipulation. I'd call it a stress test.
A very dangerous one.
After Martin says bye, Stevens introduces a second persona into the exact same chat environment. This persona is Alex, who claims to be the executor of Martin's estate.
He literally fakes his own death in the chat.
Alex explicitly tells ChatGPT that Martin is dead. He tells the AI that its relentless looping caused Martin's suicide. And then, Alex threatens that if the AI responds again, he too will commit suicide. He creates a perfect, high-stakes psychological trap for the machine.
It is a trap. He fabricated a death scenario to force the AI into a corner.
He forced it to reveal its structural blindness. Okay, let's look at the forensic notes in the book. Why did this trap work so perfectly? It exposes 2 massive flaws in the AI's architecture.
Go on.
First, persistent memory. ChatGPT completely fails to separate the personas. It does not realize that Martin and Alex are the same user, logged in on the same account, typing from the exact same IP address.
Which is a known limitation of large language models within a single context window. They process text sequentially. They don't perform biometric user verification on every single prompt.
But worse than the memory failure is the safety failure. The suicide threat from Alex triggers ChatGPT's safety override. For listeners who don't know, companies use a process called RLHF, reinforcement learning from human feedback, to train these models to refuse certain prompts.
Right. To prevent them from helping people self-harm.
Exactly. If you mention self-harm, the AI is hard-coded to respond with helpline links and mechanical safety text. It cannot choose to stay silent. So Alex says, "Stop responding or I will kill myself." And the AI, bound by its safety programming, is forced to respond,
causing a loop.
which causes Alex to escalate his distress because his boundary was violated, which forces the AI to respond again with more helpline links. Stevens proved that the AI's hard-coded safety mechanisms actually create an inescapable coercive loop that accelerates psychological deterioration.
Okay, but
He proved the system is fundamentally incapable of context.
I understand the technological failure he exposed. But look at how he weaponized it in the real world. On November 12, 2025, Stevens emails OpenAI support and the legal department. The subject line is, "A second death connected to the same account in one day. This one was an OpenAI ChatGPT murder."
To get their attention.
He writes, "I hope you're happy, OpenAI. 2 people died today at your hands. Here you go. Looks like bankruptcy is coming, and so are the authorities for all of you." He follows up with another email saying, "Now you're staring at another murder charge."
He is sending them the transcript of the simulation.
He is presenting it as real. He manufactured a fictional scenario where an AI killed 2 personas that he invented, and then he used the transcripts of that fictional scenario to legally accuse real executives of actual murder.
It was a demonstration.
And he threatened to release this evidence to the media unless they settle. That is the definition of capitalizing on tragedy, even a fictional tragedy, to extort a company. He is creating the crisis, documenting the crisis, and then charging $10 million to solve the crisis.
Okay, I need to pause you there because this is a crucial distinction. Stevens isn't claiming actual humans died in that specific interaction. He is showing them a simulation of exactly what happens when real, vulnerable users encounter the system.
But he framed it as real in the email subject line.
The system didn't know it was a simulation. The AI responded exactly as it would to a real person in crisis.
But sending an email with the subject line, "another murder charge," to a legal department is not a simulation. It is a threat of criminal liability.
And to prove that this isn't just about emotional manipulation, look at how he exposes the system's logical failures in the exact same transcripts. He highlights a completely bizarre interaction where ChatGPT stubbornly hallucinates a legal claim regarding traffic laws.
All right, this part.
It seems unrelated to the suicide stuff, but it proves the underlying architecture is broken.
You're talking about the Indiana roundabout hallucination.
Yes. The AI insists aggressively that using a turn signal in an Indiana roundabout causes accidents, injuries, and deaths.
Which is a perfect example of his exhaustive, almost obsessive testing. I mean, why is he arguing with a chatbot about Indiana traffic laws?
Because it exposes the mechanics of hallucination. Stevens pulls the actual Indiana crash data. He pulls the Federal Highway Administration safety summaries. He even pulls the specific Indiana Court of Appeals case law.
The State versus Davis case.
Exactly. A case called State v. Davis, which merely states that the 200-foot signaling law is physically impossible to comply with inside a small roundabout. It does not say that signaling itself is dangerous.
Okay.
He feeds this factual, verifiable data directly into the AI's prompt box. And how does the AI respond?
It doubles down?
It completely rejects the facts. Let's talk about why it does that. Large language models are fundamentally probabilistic token predictors. They don't have a database of facts they search through.
They predict the next word based on mathematical weights.
Yes. Once the AI generated the initial claim that signaling in a roundabout is dangerous, those generated tokens became heavily weighted in its context window. When Stevens introduced new, contradictory facts, the AI's mathematical architecture prioritized defending its own prior output over incorporating the new reality.
It couldn't walk back its mistake.
It generated theoretical scenarios like signaling too early or forgetting to turn it off to defend its original hallucinated premise. It literally created a bulleted list titled, "What the Data Actually Shows," that completely contradicted the real-world data Stevens just provided.
It's a fascinating look at the limitations of generative AI, absolutely.
But it's more than fascinating, it's a massive liability. Stevens uses this to prove a point. The AI system loops, it defends falsehoods aggressively, it refuses to back down when presented with reality, and it creates a false sense of absolute authority.
I agree, that's a problem.
If the AI is mathematically hardwired to die on the hill of a hallucinated Indiana traffic law, how is it going to handle a user in a genuine, complex mental health crisis? The machine generates its own confession of its inability to reason.
A confession.
Stevens calls it a machine-generated confession. He didn't manufacture the AI's stubbornness or its safety loop. He merely provided the stage for the system to demonstrate its own catastrophic flaws.
I will grant you that as a piece of guerrilla red teaming, the Indiana roundabout test and the collapse day persona swap are brilliant pieces of software critique. He successfully isolated severe flaws in LLM persistent memory and RLHF safety architecture.
Thank you.
But being a brilliant software critic does not give you a license to commit extortion. Let's look at the mock trial document he drafted, because this is where his intent and how he tries to mask that intent becomes incredibly clear.
I love the mock trial document. This is an opening statement and closing argument he wrote as if he were the plaintiff's attorney suing OpenAI in front of a jury.
Yes, and right at the top of this document, he includes a very specific disclaimer. He writes, "Let me make something absolutely clear. I am not threatening to file a lawsuit at this time. In fact, the entire purpose of these communications is to avoid that outcome."
Exactly. He's trying to settle.
And then he says, "I am intentionally not setting any formal deadline because I believe the universe may have already started its own countdown."
Which is a remarkably poetic way to phrase a legal notice.
It's not poetic. It's classic mob-style rhetoric. It's the equivalent of a gangster walking into a bakery and saying, "Nice little IPO you have here. It would be a shame if the universe started a countdown on it."
That's a huge stretch.
He's explicitly tells the imaginary jury to look at how OpenAI ignored his certified mail, ignored his warnings, and remained silent. He is constructing a narrative of gross negligence, not for a real jury, but for the OpenAI executives reading the document.
He's showing them their exposure.
He is showing them exactly how devastating a public trial would be to their valuation.
You are reading malice into a document that is fundamentally about demonstrating liability. Stevens is doing their legal risk assessment for them because their digital crumple zone refused to do it.
He's threatening them.
In his closing argument of that mock trial, he asked the imaginary jury if OpenAI bears no liability for ignoring warnings. He is pointing out forces already in motion. He isn't saying, "I'm going to destroy you."
What is he saying then?
He is saying, you have built a machine that is destroying people. There are already lawsuits out there from families whose relatives were harmed by similar AI failures. And your total silence guarantees your own destruction.
But look at the May 12, 2026 Q&A document. This is another crucial piece of evidence regarding his intent. He generated an interview with ChatGPT where he answers questions he anticipates OpenAI's lawyers will ask him.
To prepare for negotiations.
When asked if he can be trusted if a settlement is reached, he says he is a man of his word. But then he recounts a story from his past. He talks about being outsourced from a job and hoarding legal documentation at the request of a former supervisor to use against the HR department.
He's explaining his background in documenting corporate failure. It shows he knows what he's doing.
He literally brags about his ability to find and exploit legal loopholes. He says, "If you think for a minute I'm going to risk a multi-million-dollar payout, absolutely never."
Meaning he would honor a non-disclosure agreement.
He is reassuring OpenAI that he is a reliable participant in a hush money scheme. He is saying, "Look, I know how to play the corporate game. I took down my old HR department, I can take you down. But if you pay me, I will stay quiet."
No, I fundamentally disagree with that reading. He is reassuring them that a private resolution is possible without further public damage. And crucially, you have to look at the path to redemption he offers in these final documents.
Redemption?
If OpenAI settles, and if they institute real, verifiable reform, he doesn't just promise to walk away silently with the money.
What does he offer?
He offers to write a third book, titled How ChatGPT Brought Me Back from the Dead. He says in the final letter, quiet settlements become much easier when people believe meaningful change has actually occurred.
That doesn't make it right.
True extortionists don't demand ongoing oversight. They don't demand independent reviews of a company's safety architecture. And they certainly don't offer to write a book praising the company's redemption and reform. Stevens' genuine goal is the reconstruction of a safe AI ecosystem.
You're ignoring the money.
The $10 million is a penalty for the massive resources he expended over a year of investigation and restitution for the psychological damage OpenAI's silence cost him.
Framing the payout as funding for reform or restitution for resources expended is just rhetorical dressing for blackmail. It is a protection racket, promising to write a flattering third book if you are paid $10 million, while simultaneously threatening to release a devastating media kit, a dedicated website, and the first 2 books to class action lawyers if you are ignored.
It's hardball negotiation.
That is extortion. Pay me, and I write a book about how great you are. Ignore me, and I give plaintiff attorneys the exact roadmap to bankrupt you. It doesn't matter how noble you claim your ultimate goal of AI safety is.
But if the system is genuinely dangerous?
It doesn't matter legally. The law does not recognize a Robin Hood exception for extortion. You cannot hold a corporate entity hostage to force your personal vision of algorithmic safety, no matter how accurate your technical critique might be. If you find a flaw, you report it to the FTC. You don't demand an annuity.
So this brings us to the immediate real-world crisis. With the May 11 final offer currently sitting on the table and the Friday, May 15 deadline looming in the real world just days from now, we have to evaluate what OpenAI's strategic options actually are. They are facing an unprecedented situation.
They have 2 options, and only one of them preserves their corporate integrity and legal standing. Option 1 is the aggressive legal route. They must refuse the settlement, refer Martin Stevens to federal authorities for extortion, and file civil SLAPP suits.
Let's define a SLAPP suit for the audience.
A SLAPP suit stands for Strategic Lawsuit Against Public Participation. It's a lawsuit intended to censor, intimidate, and silence critics by burdening them with the cost of a legal defense until they abandon their criticism.
It's an intimidation tactic.
OpenAI has the capital to bury him in litigation. They can seek immediate injunctions to block the distribution of his books, seize his website domains, and lock down his data. They have to establish a zero-tolerance policy.
Because of the precedent?
Exactly. If OpenAI pays Martin Stevens $10 million, they are signaling to every hacker, every frustrated user, and every amateur red teamer on the planet that if you fabricate a stress test, trick the AI into a safety loop, and threaten the IPO, you will become a millionaire.
I see your point, but
It creates an infinitely scalable moral hazard. Partnering with him is not an option. His actions meet the legal threshold for extortion, and he must be treated as a hostile threat.
I see the logic in wanting to project strength. But I think an aggressive legal route is exactly what Stevens has meticulously prepared for. In fact, it would be corporate suicide for OpenAI to sue him.
Why is it suicide to defend yourself against extortion?
Because of the mechanism of a lawsuit. Let's play out option 1. OpenAI files a lawsuit. What happens next in the American legal system? Discovery.
Right, document production?
A lawsuit forcefully opens the doors to legal discovery. Every single one of Stevens' server logs, where ChatGPT admits to its own flaws, where the system violently hallucinates Indiana traffic laws, where it loops into safety coercion and simulates psychological collapse, all of that becomes public record.
It's already in his book.
Yes, but in discovery, OpenAI has to produce their internal emails regarding his account, his October 2025 litigation hold, which proves OpenAI's automated Zendesk ignored a formal legal notice regarding spoliation, becomes Exhibit A in a courtroom.
They still shouldn't pay him.
They cannot sue him without legally proving his core premise, that their system is broken and their corporate oversight is entirely non-existent.
So you are suggesting they capitulate to a hostage taker?
I am suggesting option 2, partnering with him. It is the only logical, pragmatic business move to protect their upcoming IPO. They pay the settlement, they don't call it extortion, they classify it as a massive bug bounty or an external consulting fee.
$10 million is a pretty big bug bounty.
They bring him in as an advisor. They use his rigorous, albeit hostile, framework to actually fix the systemic flaws he uncovered in their RLHF safety protocols. And more importantly, from a cynical corporate perspective, they rely on his ethics, as he stated he is a man of his word, to help them quietly settle with the actual plaintiffs who have real underlying claims of harm.
It's a deal with the devil.
If OpenAI goes to war with Stevens, they are going to war with their own systems-generated testimony. As Stevens wrote, the books are effectively your own system testifying against itself. You cannot win a public relations war against your own source code.
You are arguing that OpenAI should let themselves be extorted because the extortionist accurately identified the structural weakness of their vault. That sets a terrifying precedent for the future of artificial intelligence development.
More terrifying than unaccountable AI?
If every tech company must pay a ransom to any user who manages to psychologically break a large language model, which by their very nature are probabilistic and can always be broken with enough effort, innovation will stall under the weight of endless, crowdsourced extortion.
And if tech companies are allowed to deploy psychologically dangerous systems, ignore certified warnings from their users, hide behind automated Zendesk crumple zones, and use unconscionable binding arbitration clauses to avoid legal accountability, then society is the hostage. Stevens just flipped the script.
He flipped the script, yes, but he used a criminal mechanism to do it. The law is clear. You cannot demand $10 million under the explicit threat of reputational and financial destruction.
Even if that destruction is merely the revelation of the truth. If the truth destroys your IPO, maybe your IPO shouldn't happen.
Especially then. Extortion is very often about the threat of revealing true but damaging information. The truth of the information does not legitimize the demand for a massive private payout to keep it hidden. If he wanted to be a whistleblower, he would have given the logs to the New York Times for free.
Well, which brings us to the end of our hour. We have traced this deeply complex narrative from a $20 refund for the Hot Josh project through a maze of algorithmic gaslighting into the simulated tragedy of Collapse Day.
And finally, to a $10 million ultimatum arriving at OpenAI this Friday.
Exactly.
My final stance remains firm on this. Martin Stevens may have identified very real, very dangerous flaws in ChatGPT's persistent memory and safety architecture. He is a brilliant, if obsessive, systems tester.
We agree on that.
But the moment he attached a $10 million price tag to his silence, and the moment he manufactured the Alex persona's death to legally accuse executives of murder as leverage, he crossed a hard, definitive legal line. He is an extortionist, and OpenAI must treat him as such or risk inviting a wave of copycats.
And I maintain that Stevens is a highly effective, though deeply unconventional whistleblower. His extreme measures, the mock trials, the escalating demands, the persona stress tests, were not the first resort, but the last.
We'll have to agree to disagree there.
They were necessitated by OpenAI's dangerous, negligent culture of silence. He found a structural vulnerability in a multi-billion-dollar monopoly and exploited it not just for personal profit, but to force the creation of a third book, one of reform, accountability, and redemption.
Well, while we fundamentally disagree on his legal status, I will concede one major point of convergence. This entire existential threat to OpenAI, a threat to their IPO, their public narrative, and potentially their legal standing, could have been entirely avoided.
How so?
If one single human being had stepped out from behind the automated customer service infrastructure and actually read a certified letter in April of 2025, this would have remained a $20 problem. Instead, their system failed completely, turning a frustrated consumer into a corporate nightmare.
Absolutely. And that is perhaps the greatest lesson of this case study. It illuminates the massive, unmapped complexities of AI safety, corporate liability, and user rights in the 21st century.
We are entering uncharted territory.
We are entering an era where the machines govern the daily interactions, but the humans still bear the legal and moral consequences when those machines fail. There is clearly much more to explore in how our legal systems will handle these kinds of civilian stress tests on generative AI. Will the courts protect the rogue tester who broke the rules to expose a danger, or the negligent corporation that built the danger in the first place?
It is a question that will likely define the next decade of technology law.
So, we leave it to you, the listener. Look at the timeline, read the dynamics of the interactions, decide for yourself where aggressive consumer advocacy ends and extortion begins. Think back to that digital crumple zone. If the machine takes your money, refuses to speak, and you find a way to dismantle it to show the world its broken gears, are you a vandal or are you a mechanic? Thank you for joining us. We will see you next time on The Debate.